We now move to the report and recommendations of the task force on the New York State bar examination to be presented by the presiding justice and of the Appellate Division Second Department and a member of our House of Delegates and the chair of the task force. He wears many hats, the Honorable Alan Scheinkman. Judge, the floor is yours.
Thank you very much, Scott. Can everyone hear me?
Your sound is very muffled. Can you get a little closer to your microphone?
Can you hear me now? Is that okay?
I can. Are there other members who are having problems? Well, just talk as loud as you possibly can. And
thank you. I will endeavor to do that. Is that better?
Yeah, I can hear you.
So I want to thank you, Scott, and I'd like to thank the members of the House for affording me this opportunity to present the report of our task force. And I do make this presentation on behalf of the members of the task force who work very hard and very dedicatedly on this issue. I would in particular like to recognize and thank Michael McNamara, who together with his associate Andrew Matat played a significant role in the drafting and editing of the report. And I would like to thank Tom Richards of the State Bar, who served as our liaison. We were established by then President Michael Miller last year with the charge of investigating and reporting on New York's adoption of the Uniform Bar Exam. The effect on bar applicants' qualifications and relevant legal knowledge of newly admitted New York attorneys, on potential employers, on members of the bar, on the court system, and on diversity in the profession. We spent almost a year working to fulfill our charge. We met with both New York and national experts on bar examination administration, with the deans of the law schools located in New York, and we held 4 public hearings, 1 in each department of the state. All of our meetings and public hearings were live streamed. All of our research materials were posted on a virtual library on our portion of the NYSBA website. Before we deliberated on what would become our findings and recommendations, we afforded the Board of Law Examiners, who had been carefully monitoring all of our activities, the opportunity to submit a written response to the concerns that we had been hearing. That written response is actually included as one of the appendices in our report. We also had a meeting with them. We invited them in, and the chair and several members and the executive director of the Board of Law Examiners came and discussed the matters with us. On March 5th, we issued our report, which was posted and available to all NYSBA members on March 10th. Since then, I have made presentations of our report either in person or by video to the New York County Lawyers Association, the Nassau County Bar Association, the Brooklyn Bar Association, the Onondaga County Bar Association, the Erie County Bar Association, and the Westchester County Bar Association, all of whom, together with the Bronx and Queens Bar Associations, have endorsed the report, as did the executive committee of this association yesterday. I would like to take a few moments of your time to highlight our findings and recommendations, and would certainly invite your questions and comments. While we have been called the task force on the New York bar examination, the simple fact of the matter is that we no longer have a New York bar examination. What we have is the Uniform Bar Examination, which tests general principles of law. The only New York components of the bar admission process are something called the New York Law Course and something called the New York Law Examination. The New York Law Course is basically an online CLE. And like all good CLEs, every once in a while, the viewer is required to respond to a question. If answered correctly, the viewer gets to advance to the next section of the materials. If answered incorrectly, the prior content is repeated. For those of us who are old enough to remember the old folk song about Charlie and the MTA, I guess if you never give the right answer, you never get off the train. The New York Law Examination is a 50-question multiple choice test, which is administered online. It is open book, and 30 correct answers, that is 60%, a score of 60%, is sufficient to pass. The proponents of the UBE, when it was adopted some 3 years ago, was that it promotes portability, so that law graduates don't have to take multiple tests in multiple jurisdictions in order to practice in each jurisdiction. Essentially, we conclude that there are two flawed assumptions in this. A, that most students want to practice in multiple jurisdictions in their first 3 years after graduation, because a UBE score is only good for the first 3 years. And B, that state law, and in particular New York law, is consistent with general principles of law. Since the adoption of the UBE, a number of things have happened, and we have made a number of key findings. They are, first, that the New York law examination is widely regarded by students, faculty, and law school deans, and I will say this politely as I can, a farce or a joke. While the Board of Law Examiners has impliedly conceded that the original questions were too easy because they have told us they tried to make them harder, the fact is that it is not taken very seriously. While some proponents of this examination, when this was being proposed, claimed that the exam would be rigorous, it is not, and the Board of Law Examiners does not claim that it is. They now say that the exam was not designed to be a significant barrier to entry into practice. It's not designed to mimic a bar exam. It is designed simply to expose candidates to New York law to some degree. One might call it a consciousness-raising experience. The absence of New York law from the bar examination and the testing of general principles has led to a drastic reduction in the teaching of New York law. While this can most readily be seen and clearly be seen in the dramatic decrease in the number of students who take a course in New York civil practice, it actually cuts across the curriculum. We have learned that despite what was advocated at the time, or what was predicted at the time the UBE was adopted, many law schools teach to the exam. And many law students only want to know what they need to know to pass the exam. Can't be surprised at that. Students are goal-oriented. Their goal is to pass the bar at the end of their experience. Law schools can't be surprised at this either. Increasingly, they are accredited and rated on the basis of their bar passage rate. Therefore, they put emphasis on helping students pass the bar. So, for example, a class on criminal law that might have been taught previously at a New York law school might well talk about general principles, but then it might also advert to the, as examples, specific illustrations of the New York criminal penal law or the New York criminal procedure law. That discussion about New York law gets dropped now. Why? Because there are only so many credit hours in a law school class. Material that has to be added because it's tested on the UBE comes in. So, for example, they spend time now talking about the model penal code. The classic is the model probate code, which they teach at law schools. Why? Because it's tested on the UBE, although I don't believe very many, if any, states have actually adopted it. Now, it is true that prior to the adoption of the UBE, there were some law schools, including some in New York, that didn't really have any courses in New York law. However, there were also robust bar review courses. Many of us took them, whether we went to New York law schools or not, that filled any gaps. That's what you did between your graduation in May and taking the bar in mid-July. When I took the PLI bar review course, our New York practice teacher was Dave Siegel. Our evidence teacher was Judge McLaughlin. That doesn't exist anymore. Why? Because they're only tested on the UBE. The bar review courses do not attempt to fill the gap by teaching New York law. Apart from this, we have discovered some serious issues with the UBE, way the UBE is scored. It is not, as promised, scored uniformly. It is difficult to get transparency on this because the National Conference of Board Examiners, which writes the exam, treats its exams and its scoring methodologies as trade secrets. However, as we have learned, the UBE is scored relative to the people who take the test in a particular state. So if you take the test in New York, your score is based on how everyone else does in New York. If you take the test in another UBE state, even it's the same test administered at the same time, Your score is relative to whoever else took the test with you. So that means that with the same number of correct or incorrect answers on the same exact test, you could get a higher or lower score depending upon where you took the test. This could be a real problem, for example, in the current environment where now that New York has voted to postpone the bar exam into September, but other states may administer it in July. What happens if people from New York elect to decide that they want to go take the test in another jurisdiction? And they get a score, and then they want to transfer that score back to New York. That's the illustration of the sort of problems that this has created. In addition, the UBE gives more weight to multiple choice tests, the multiple choice answers, than it does to essays, on the theory that objective test grading is more reliable than essay grading. Women do better on essays than men. Men do better on multiple choice tests than women. Hence, the scoring on the UBE has a disparate impact on women, because by weighting the scores more heavily towards objective tests where men do better, it creates an inherent bias. A study commissioned by the Board of the Law Examiners to reevaluate the UBE agreed that this disparate impact exists. However, they did not propose a solution. Instead, they reported that the disparate impact was no worse than the disparate impact had ever been before the adoption of the UBE. Our task force did not find that a very satisfying answer. I don't think it's an acceptable answer to say, yes, we know that there's a disparate impact, but we don't propose to do anything about it. By the way, the study that the BOLE had done was done by a group that was sponsored by the NCBE itself, which is sort of like having an author of a book do his or her own book review. We have learned from lawyers, faculty, and judges that there's been a real decline in lawyers' knowledge of New York law, as well as a real decline in the quality of legal writing. Just anecdotally, this association, Sharon Stern-Gerstmann will know about this, sponsored a program which was called CPLR 101, which was designed to teach New York lawyers New York civil practice. My topic was to talk about the jurisdiction of the courts. And I was struck by how many people who were already admitted to practice in New York had little to no idea of the jurisdiction of, for example, the Court of Claims, or the necessity for a notice of claim before you sue a municipality. We have learned that it is harder for law graduates to get positions with small or mid-sized firms or sole practitioners. It is simply no help to the small firm or sole practitioner to have a new lawyer, to have to teach a new lawyer what a return date is, or how many signatures are on a will, because it's easier and faster to do it yourself. Even with the advent of clinics and pro bono practice, students are just not prepared to practice law in New York, and we conclude that it is absolutely wrong for us to give them a certificate that says they are qualified to do so. So what do we recommend? First, we recommend that we eliminate the New York law exam. It is widely regarded, as I said, as a farce or a joke, an embarrassment. There's a high incidence of cheating on it, although we are sort of puzzled as to why one would cheat on an examination that is so easy to pass. But rather than have no New York content at all, we propose that New York once again have a robust, real New York test. Now, we recognize that one cannot be can only partly be in the UBE. You're either in or out of it. And there are people for whom the UBE makes some sense. For example, about 1/3 of the people who now take the bar exam in New York are foreign law school graduates. These folks come to the United States and come to some of our New York law schools to learn New York law or to learn American law and go back to their foreign countries. They have no interest in practicing law in New York, so it doesn't make sense for us to force them to learn it. On the other hand, we give them an admission certificate that says they're licensed to practice here. And it's very hard to distinguish their license from anybody else's. So we propose that if people want to take the UBE in New York continue to offer it. You just don't get admitted. The only way you get admitted would be by taking the old multi-state and a rigorous New York test. If you want to practice both in New York and someplace else, then that would add an additional day of testing, which could be a hardship. We recognize that. But what's more important? Protecting the public by assuring that there's a minimum amount of competence in a New York lawyer, or making it somewhat easier for people. And by the way, this falls into a small category because everyone tells us that most of the law students who go to law school in New York stay in New York. A real New York test, I would add, would include not only New York law, but some subjects that are not tested on the UBE at all. Remember, it's designed by a national organization that reflects their priorities, not necessarily anybody else's. Some subjects that are not taught at all, are not tested at all on the UBE, and therefore are not emphasized at all in law school or by law students, include such matters as data privacy and healthcare law. It would having a real New York test would also mitigate our absolute dependence on the NCBE and its scoring mechanism. And in that regard, we urge the retention of an independent psychometrician. That's a new term that I learned. A psychometrician is somebody who specializes in the science of testing to study the scoring of the UBE. We also posit a pilot program to offer a diploma privilege to students who attend an ABA-accredited law school and who successfully complete a stated number of credits in New York law or courses with a stated amount of New York law content and a stated grade point average. By concentrating on learning New York law in law school and concentrating on showing sufficient grades, we think these students could potentially be admitted without a bar exam. If such a program existed now, we would not be in the quandary that we're in, with law students from around the country clamoring for a diploma privilege because of the difficulties in administering the test. In concluding, I would mention that we made 2 edits to the report that I think were published last night. First, we added 3 footnotes in order to give proper credit to Professor Derek Mueller of Pepperdine for certain work he did. And in response to a question that was raised in a discussion that came up during the executive committee, we also added a reference to the existing rules of the Court of Appeals that permits a candidate to take the bar exam with a combined number of 4 years of practice in law to study. And with that, I thank you for listening to me. I recognize this is a complex subject, and I've tried to do the best I could to synthesize it in as short a time as possible. Thank you.
Thank you, Justice Scheinkman. And we appreciate the report. And I will report to you now that at yesterday's meeting, the executive committee voted to recommend approval by the House of Delegates of the report and recommendations of the task force on the bar examination. Do I hear a motion? Justice Scheinkman, you can make the motion if you care to do so, since you are a member of the House. Do I hear a motion to approve the report and recommendations?
I so move.
Okay, is there a second?
Second.
Okay, the motion has been made and seconded, and we have a couple of folks who have indicated a wish to be heard in connection, and we will start with past President Michael Miller. Mr. Miller.
Thank you, Mr. Chair. You folks heard earlier from President Greenberg regarding Justice Scheinkman's extraordinary leadership regarding the emergency report that was issued last week pertaining to the cancellation of the July bar exam. And I just want to add to that, at breakneck speed, the task force met several times during 1 week, and issued a very thoughtful report with recommendations, which, as you heard, were adopted by the Court of Appeals in 48 hours. And a lot of folks put in a good deal of time, but Justice Scheinkman's leadership was truly extraordinary. The term blue ribbon panel often gets overused, but this task force was truly an extraordinary team with extremely talented, dedicated, and engaged members, deep thinkers, committed to the finest values of our great profession. The task force included past and present bar presidents from various bar associations around our state, as well as thought leaders on bar exams from academia, the chair of our Committee on Attorney Professionalism, a former member of the Judiciary and New York State Assembly, and additionally, 2 members of the task force were also members of our Committee on Legal Education and Admission to the Bar. As well, the task force benefited greatly from the participation of Associate Judge of the Court of Appeals, Michael Garcia, who was liaison to the court and attended most of the task force meetings. The mission of the task force was to investigate and report on the experience and impact of New York's adoption of the Uniform Bar Exam, and that is precisely what it did, as you just heard. The task force undertook a unbelievably ambitious agenda, had lengthy meetings with experts on time pressure exams in general and bar exams in particular, who provided insights into the development, history, metric evaluations of the UBE and the so-called New York portion of the exam. And as you heard, it also heard from the Board of Bar Examiners and held public hearings around the state at which anyone who wanted to share their thoughts and concerns were welcome. Thanks to Justice Scheinkman's determined, inspired, and truly extraordinary leadership, in less than 1 year, an intense and thorough investigation was conducted, consensus was achieved, and this thoughtful and comprehensive report with more than 350 footnotes was adopted unanimously by the task force. And in addition, in reflection of the incredibly strong report for the task force's conclusions and recommendations, as you heard, the report was adopted by the Board of Directors of the Erie, Onondaga, Westchester, Nassau, New York, Bronx, Queens, and Kings County Bar Associations. So thank you to the task force members for your time, energy, and experience, and most especially, thank you, Justice Scheinkman, for your absolutely brilliant leadership. I strongly urge this House to approve the report.
Thank you, Mr. Miller. The chair will now recognize Professor Michael Fox.
Thank you, Mr. Chair. I have a procedural motion, though, so should I wait until the very end?
Yes, please. Just make your comments now, and we'll come back to you for the procedural motion.
Certainly. So I won't make the motion now, but the comments that back up the motion.
We'll follow the Doyle procedure. Yes.
Okay. So Michael Fox, delegate from Orange County. But in this regard, I'm actually speaking in my capacity as a member of the Committee on Legal Education and Admission to the Bar. Our committee met this past week, and these comments have nothing to do with the merits up or down of the report or the great work of the committee. But the committee noted that it was not involved in the creation of the report or the work of the task force, or the constituency was not consulted. And while it sounds like there may have been a member or 2 of the task force, the Committee on Legal Education and Admission to the Bar noted some consternation amongst the members who are practitioners, deans, professors, that their work over the past number of years on these issues of legal education, the bar exam, admission to the bar, was not involved with this report. So similar to other objections we've heard in the past from sections or committees, the motion that I will be making would be a motion to table, not indefinitely. We recognize the urgency of this issue, but I was just asked to pass along the thought of the committee requesting a motion to table maybe to a special meeting in May on this issue, just so the constituency and members of the Committee on Legal Education and Admission to the Bar would have a chance to weigh in on this and provide their experience and expertise as well. But I'll hold on the actual motion until then, but thank you.
Thank you. I have a note that Peter Kiernan would like to be heard on the main report recommendations. Mr. Kiernan, you have the floor.
That's an error. I don't have comments other than praise to the committee that put together the report.
Okay, well, thank you for that succinct comment. I'm just checking. Tom, do we have anybody else wishing to be heard? I'm not showing anybody.
Andrew Shriver's hand is raised, as is Ron Minkoff's and Ann LaBarbera's.
Okay, Mr. Schreiber, you have the floor.
Can you hear me?
Yes, please.
Okay, thank you. I'm Andrew Schreiber from the 9th Judicial District. I'm also on the Executive Committee of the Westchester County Bar Association, and I simply wanted to thank Judge Scheinkman and the committee for the report. When we met on the Executive Committee, one note that struck me in particular was the importance of essays in terms of revealing a student's actual knowledge of the subject matter, as opposed to multiple choice, where you have a situation where a little guesswork. I'm sorry, but I'm not sure if I just got shut out. But just to finish the thought, I think that the committee's points about needing New York practitioners to come in knowing more about New York law and being able to demonstrate their subject matter expertise in a way that's more particular to the state, I think is extremely well founded. And I just want to commend the committee on that type of thinking that went into the report.
Thank you very much. Did I understand that Mr. Minkoff wishes to be heard?
Yes, I do.
Okay, please proceed.
Thank you. First of all, I want to thank the task force for the report, and in particular for adding the footnote that you added to recognize that we have an experiential way of becoming a lawyer in New York that often gets forgotten about. And in listening to the Rural Task Force report, I was just thinking how great it would be if we could communicate to college students and first-year law students the ability to become qualified for the bar by just doing 1 year of law school and then working with a lawyer. That would be the ideal way for many rural communities to get lawyers integrated and coming up into their system. So as an association, we should consider making a better effort to communicate that to people, that option is available. Second, though, I have to say that while I completely agree that the New York law examination is kind of a joke, as someone who represents people who've been accused of cheating on it and who knows a lot of first-year law students, lawyers who've taken it, and while I can certainly agree that the UBE should be examined and consistently re-examined, I don't believe, and I feel very strongly, that New York should not walk away from the UBE regime. Students, young lawyers do have to move out of the state. Sometimes their firms make them move out of the state, and they don't know that that's going to happen before they take the bar. That happens after they start working. And sometimes they need to move for other reasons. So it is practically something that they need. But more importantly, this association has, over the last 20 years, consistently supported multi-jurisdictional practice and making it easier for lawyers to move across state lines. And this would be a move in the other direction. We'll invite retaliation from other states in terms of our lawyers moving into their states. It also affects the ability of lawyers in other states from moving here if we want them to come here. So I think it would be a move backwards in terms of our leadership and our role in multi-jurisdictional practice. And I think we should not walk away from the UP regime. We should just keep working to make it better. Thank you.
Thank you, Mr. Minkoff. Tom, who else wanted to speak?
Ann LaBarbera.
Ann LaBarbera. Ms. LaBarbera, you have the floor.
Okay, can everyone hear me?
Yes.
Okay, yeah, I'm with the young lawyers section, but I'm just speaking in my personal capacity just now. I wanted to remind people as they're considering the report that not everyone has gone to law school in New York. I went to law school actually in another country. And before I took the bar, I took the old bar exam back in 2014. And before I took the bar exam, I had no familiarity whatsoever with the CPLR. And now 5 years later, I'm a civil litigator. And I have to say, it probably would have been dangerous to license me before having any familiarity with the CPLR. So I just wanted to re-up what the judge said about the Barbary course. Might possibly move away from focusing on the CPLR if you don't have to understand the CPLR to pass.
Okay, thank you very much. Are there any other speakers? Tom, do you have anybody else?
Doesn't appear so.
Hearing none, we will now, I'll now recognize Michael Fox, Professor Fox, once again, for the purposes of making a procedural motion.
Thank you, Mr. Chair. I just have a question that we're still waiting in the chat from Tom, whether it should be a motion to postpone. I was asked by the committee to make a motion to table, but not indefinitely, just until
Well, that's
the date
what
in
you're
May.
talking about. What you're talking about is a motion to table, which puts the motion on for later consideration. A motion to postpone just basically kills the motion, kills the other motion because it's indefinite. It just disappears. So you're talking about moving to table, and I assume that's what you want to do. So make your motion.
Yes, we don't want to kill it. So I'm just making a motion to table potentially to a meeting date in May to allow the constituency of plebe to address the issues.
Okay. That motion requires a second. Is there a second? Is there a second to Professor Fox's motion?
Looks like there's one in the chat. There are a couple.
Yeah, it appears that it has been seconded. Okay. So it's a non-debatable motion, so we will proceed to a vote. All in favor of tabling? Do you have? Let me go backwards. Did you have a date certain, or did you want to table it to the next meeting of the House?
Actually, the consensus of the committee was maybe to a date in May. We recognize the urgency, so they thought if there could be a special meeting rather than push it into June.
Well, then we'll just leave it as table with the understanding that if the motion carries, it'll be rescheduled to a later convenient time. The motion has been made, seconded, and we'll continue with the vote. Can we post the polling screen, please, or the polling icon? We have it. Please vote now, and we will record your votes as they're made. Remembering that if you voted to abstain, identify yourself.
it's going up to 57 degrees this afternoon.
I can't hear you. What?
Tomorrow's sunny, going up to 66.
Did you?
Nobody wants to relieve you.
I'm not here. Whoever's speaking, I'm not hearing you.
No, I think whoever's speaking needs to put their phone on mute or their computer on mute. If you're not speaking to the meeting, please put your computer or your phone on.
If you are speaking, get close to the mic and speak up. Okay. Let me just double check. This is a simple majority motion, and the motion fails. So we now proceed. The motion to table fails. So we now proceed with the vote on the main motion. All in favor? Well, no, I'm sorry. Could we post the voting box on the main motion, please? Old habits die hard. Okay. You have on your screen now a voting box to vote on the task force on the bar exam. Has everybody voted? Are we ready to post the results? Okay, it's been over 2 minutes, so I'd like to conclude the voting, and let's get the tally up so we can move on. Okay, the motion carries. The report of the task force on the New York bar examination is approved. Thank you all very much. And in particular, thank you, Presiding Justice Scheinkman, and to the members of your task force as well for your great work.
Thank you.
I'm sure you have the thanks of the House and of the association.